The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable John N. Harris, Judge, presiding. All persons having business before this court draw near, give attention, you will be heard. May God save the United States of America, the State of Florida, and this honorable court. Please be seated.
All right, good morning. Welcome to oral argument session here at the 5th District Court of Appeal. As the Marshal indicated, I'm Judge John Harris, joined on the panel today by Judge Brian Lambert and Judge Rand Wallace for our first case. We're going to take a break after the first case and then come back down at 10 o'clock to start the remaining 3 cases on our docket today. If you have any noise-making devices, please silence those or turn them off at this time so that the proceedings are not interrupted. Each side is going to have 20 minutes for their argument. Appellant can choose as much of that time as you would like for rebuttal. We will set it by default at 5 minutes, but if you want anything other than that, please let us know and we will make those accommodations. All right, first case on our docket today is 24-1343, Monago versus State of Florida. Counsel for Appellant, whenever you're ready.
Good morning. May it please the court, Matthew McLean on behalf of Mr. Monago, the appellant. I'd like to go ahead and go with the default 5 minutes for rebuttal.
Okay.
May it please the court, one of the primary issues at this resentencing for Mr. Monago following the remand from the Florida Supreme Court and this court was whether the court could consider disciplinary reports against Mr. Monago for which he was neither arrested, charged, nor convicted of.
Let me ask you, do you think hearsay is admissible in these proceedings?
No, I don't believe that hearsay is admissible in non-capital sentencing proceedings.
The Fourth DCA disagrees with that, though?
The Fourth DCA has reached a contrary decision.
They've expressly found that hearsay is admissible.
They expressly found that hearsay is admissible. Their reliance was on Rule 3.702, Rule of Criminal Procedure, basically saying that the court can entertain submissions of evidence that are relevant. However, relevancy does not, control over admissibility. And if we want to head and start with the statutes that are important in the case, we look at.
Was the hearsay in this case corroborated?
No, it was not. There was no evidence other than disciplinary reports, paperwork. There was no evidence. There was no witness. Nothing. Just disciplinary
Is your
reports.
position that, setting aside the corroboration, is even if the state brought all the corroborating witnesses, that's still absent a conviction for any of those batteries or what have you, the live testimony would not be admissible?
Correct. That's our first position.
Yeah. So I mean, it's not a red herring that the issue about the affidavits coming in. It's even if they actually, everybody whose name was in those affidavits, those DR reports, etc., came in to testify. Yeah, in 2010, he beat me over the head. You'd say you can't hear any of that.
Correct. Any sort of subsequent criminal misconduct or criminal behavior is not relevant at the juvenile sentencing proceeding. So anything.
Isn't it relevant to his ability to be rehabilitated?
At a sentence review, absolutely. Or if Mr. Monago at the sentencing hearing, contested that he was rehabilitated, then that would open the door to it. That was never our position at the resentencing proceeding.
It seems to me, if I'm understanding, your overarching theme on this issue in your briefing is if Mr. Monago was awaiting in the holding cell for resentencing in front of, I can't recall the judges, and he got into a brawl with an inmate, and then he walked in and he spit at the JA and whatever, and he's misbehaving, he's showing he's unruly, he's not rehabilitatable, that is absolutely irrelevant to the resentencing judge at that moment in time.
Yes, Your Honor, that is our position.
Now, the contrary is if he's been in prison for all 17 years before resentencing, and he's done all kinds of good things, he can actually present, like, I've got my GED, I'm faith-based, all these good things he can bring into it because it's a de novo resentencing.
I think that the state could certainly raise an objection at that time to say that it's supposed to be looking at the time.
Didn't I write something that says you can do that?
Can you write something?
Oh, yeah, already. I thought I did. That's why I don't remember.
I know that generally, speaking, there is at a resentencing that's relevant, subsequent conduct of rehabilitation.
Well, I mean, it would be pertinent to a trial judge to say, okay, this guy committed a serious crime when he was 17 and a half. We are now at age 34, post, with all these new sentencing laws for juveniles. Yeah, he comes in and says, Judge, I'm not the young man I was before. I'm rehabilitated. Please give me a chance at life. I've done well when I've been in the prison setting, and here's all my accolades or whatever term you want to use in prison. That would certainly be relevant to a trial judge, I would think, and admissible at a resentencing, wouldn't it?
So I think that the state could have an argument that the factors to be considered under 921.1401 pertain to the possibility of rehabilitation.
And
It
but
pertains
that would
to
demonstrate.
prior criminal history.
Look at how I've done. I am a guy who can get rehabilitated, and I have been. Please, when you're resentencing me, please don't resentence me to life. Give me something less with a quicker review hearing so I can be productive in society. I mean, that's why you're there, I think, at the resentencing.
So I don't disagree that a defendant should try to do that, but again, I think the state could go ahead and raise an objection and say, look, this isn't a sentence review. We're not here for a rehabilitation. We're here to sentence you under the circumstances as they existed at the time.
We take a snapshot of how things were at the date of the original sentencing, and nothing that happens after that is relevant.
That's our position, correct. And I think it's even before then, too. I think it's the date the incident occurred.
Well, how would we know he's rehabilitatable?
You would look at his prior history.
Right, so your guy was 17 in a few days, so you would look at whatever history, I guess that's a broad use of the term for somebody at that age. You look at that history when he was a juvenile and to reach a conclusion as to whether 17 years later at the resentencing he's able to be rehabilitated even though he's not the same person he was before?
Correct, that's our position, is that you have to go back in time.
So Mr. McLean, your client, I guess your position is you're able to take advantage of the fact that at age 17, that is not relevant. And here we are, what is this, the second or third resentencing that we procedurally have in place? And so your position is everything that happened in between that, even though there was a disciplinary procedure that took place with Department of Corrections, correct?
Correct.
And in that disciplinary proceeding, there was evidence that there was an altercation between your client and another inmate that involved your client using an improvised device to stab that inmate, and that improvised device was found next to your client. So there's really, I guess, no dispute as to whether or not he used that improvised device to inflict harm on the other inmate. And so despite that evidence and despite the finding from the disciplinary panel for DOC, you're saying that is not enough for the court to be able to consider that now, more than 17 years later, or whatever the resentencing is, the third resentencing now. That's irrelevant.
At the resentencing proceeding, yes, Your Honor. And it kind of, that your point encompasses all three of my primary points as far as, relevancy, improper consideration, whether there's a due process violation, just relying on disciplinary court proceedings, and then the hearsay objection as well.
Following up with Judge Wallace saying, it's one thing to say here is a piece of paper, from the records custodian at the DOC saying this is here's our paperwork from this guy. But your fella actually had hearings in front of the DOC panels to assess whether he should be disciplined. So he's gotten that aspect of due process. It seems your scenario is under Norville, that there's the bright line that Justice Perry wrote about.
Correct. And
You don't necessarily want Norville to go back up on a review. You don't want to have the Norville thing because Justice Kennedy didn't think much of your theory here.
I understand Justice Kennedy dissented in that opinion, and the
very pointedly kind of saying, what the heck?
And the makeup of the court is substantially different at this point. I certainly understand that.
I understand there, I think, if it was going to go back up.
Certainly, but according to the current law in place, that is the law of the state and hasn't been changed.
Mr. McLean, so are what you telling us at this stage that the trial court had to consider the now new sentencing factors under 921-1401-2, correct?
1401. 1402
yes,
is
1401 sub 2.
Correct. Yes, Your Honor.
So, and that would include sub J, correct? Which would be the possibility of rehabilitation.
Correct.
So are you telling us now that despite that binding statutory law that the trial judge had to consider, that aspect, that sub J, is irrelevant and should not be considered by the trial judge in completing this resentencing?
So, possibility to rehabilitate is sub J. But I don't think it can be viewed in isolation. I think also it has to view with, the possibility, not whether he's actually rehabilitated, and that goes to 921.02. And then if we look at sub H, the nature and extent of the defendant's prior criminal history. Again, the court or the legislature certainly could have said the nature and extent of the defendant's criminal history, but they used the word prior, meaning prior to the incident itself.
If this had been the original sentencing hearing for this defendant from this judge, would that event that occurred in DOC, would that be considered prior criminal history?
Can you repeat the question?
If this had been not the third resentencing, but the original resentencing of your client, would that battery that occurred in DOC be relevant as prior criminal history to consider in sentencing your client?
I don't believe it would be relevant.
Is that because there's no conviction?
No, it just wouldn't be relevant based off the factors of 921.141. And if we look at Judge Maker in, I think it was the first DCA, he's taking the position that we're taking is what's relevant is you got to put yourself back at the time of the actual incident itself and then judge him based off of that. And so, what we also have to look at is, there's the case from Garcia from the 4th, Schwartzberg from the 4th, and Love from the 2nd, and all those have to deal with subsequent criminal behavior. And the most poignant one is Love from the 2nd, and in that case there was misconduct that occurred in the jail, and the second DCA, citing to and applying Norville, said we don't see any record of any sort of conviction that followed, but or any sort of proceedings, but it would be improper to go ahead and consider his misconduct while in jail. So
let me ask this then. So let's assume, the pragmatic part of me, and I know that's a dangerous thing to talk about in appellate land of pragmatism here, but let's say your fellow's committing these batteries at wherever he's housed, and he's serving a life sentence at the time all these things are happening. So basically, if I'm understanding your position, if the state then chooses to prosecute Mr. Monago for the batteries and gets a conviction, under Norville that could come in the resentencing hearing.
I think under this court's Barnes decision that comes in. So
Barnes and Orfinger wrote at a minimum. I know you kind of hang on to that because that was actual convictions that came in, but that's at a minimum. He didn't say that the other things aren't coming in that we're talking about today, but that's neither here nor there to what I'm asking though. So if I understand, if the prosecutor in whatever circuit your fellow's been housed says, you know what, he's doing life, I'm not going to sit and spend taxpayer money prosecuting a guy on a third-degree felony over and over and over again, because what am I going to get? He's going to get, life plus. So they just don't do it. But it doesn't matter. It may actually happen. All the events happen. You seem to say because the prosecutor chooses not to prosecute and get a conviction, all that's out the window. Even if Mr. Monago, under my law school hypothetical, even if he battered somebody every single day over the last 17 years, including up until the time he walks into the resentencing hearing, all that's out the window. All that's inadmissible is irrelevant, if I understand, using your more correct.
Yes, that's our position, and I think the conviction is an important part of it, right? Conviction means that a jury has found beyond a reasonable doubt that you committed that battery or the 17 batteries you committed over all those years.
You put a distinction between an arrest is just probable, but you actually then go to a DOC hearing, for lack of a better term. So you're now they're evaluating whether this actually occurred. I don't know if they announce a standard preponderance or what standard, but it's cast a, you can't use the arrest because cops may arrest people who didn't commit the crime. But you had your due process in the hearing at the DOC, and you've lost. It's been found that you've done these things, which is indicia of how you're going to be, arguable indicia under the statute, how you're going to behave if I give you a lesser sentence and you get released, isn't it?
I
know your answer should be no.
I certainly disagree with that, and I don't think disciplinary proceedings are the same sort of due process that is accepted in criminal proceedings. And for example,
hearing as opposed to a resentencing, would these be admissible, relevant?
What proceeding?
A sentence review,
I think they would be relevant because
even without conviction.
I think as long as it's non-hearsay evidence and cooperating evidence, I think that if he's arguing that he's rehabilitated and that's what's required in a sentence review, it comes in. But under our hearsay position, you can't just rely on a piece of paper to say this happened.
I mean, again, pragmatically here, so if he's involved in numerous altercations over the 16, 17 years, and if I understand your position, I understand your overarching position, but basically is you can't just submit pieces of paper. You have to have the people corroborating. You have to bring in the various prisoners who may have been victims over the, in 2008, 2009, any of the prison officials who may have seen this, who may be long gone by this time by resentencing. That's the way it goes in order to your benefit or your client, I guess is your position.
Yes, that's our position, and perhaps this court makes a decision that makes it clear to prosecutors that if you don't get a conviction, this isn't coming in. And I think the state has certainly been on notice, at least since Barnes, that you need a conviction to be able to have it considered at the resentencing.
So that means a trial, just to clarify. Judge Lambert was saying you bring people in to testify. You actually have to, pick a jury, swear a jury, and have a trial, correct? And a conviction.
Correct. You have to be successful at the trial as well. And, Judge Wallace, you bring up the stabbing incident with the homemade weapon, and, that's something that he disputed. In the disciplinary report proceedings, we also provided the trial court with a federal complaint in which he was bringing it beyond the Florida Department of Corrections and filed a suit in federal court, and the court still considered it.
Well, how did that? What does the record show? How did that end?
You can look at the federal docket. It's not within the record, but I can tell you that coincidentally looked on the 26th. The court went ahead and partially denied a summary judgment by the Department of Corrections, finding that there was cooperation with the video evidence as far as unlawful use of
somebody
force.
caught him on tape doing this.
So yeah, there's some success to it. So certainly, it's our position that without a criminal conviction under Norville, it's improper for the court to consider it. Although,
you're about a minute and a half into your rebuttal.
Yes, I'll just make a few more points. As far as, we don't want to put blinders on courts, I understand that was kind of the reason of the Peters decision, but that's what the Florida Supreme Court has required, and that's what this court's Barnes decision requires. You needed the conviction, and they didn't have it.
Barnes, because there were, Judge Orfinger wrote the opinion because there was actually convictions. He wasn't parsing out. He had convictions. He said, at a minimum, those are admissible.
Yeah, I think he was doing more than that, as he emphasized the word "with" multiple times in his decision.
Nobody really knows what that is.
So it's our position that Mr. Monago is entitled to a resentencing before a different court or a different judge, and we'll rely on our briefs as to the other points raised.
Thank you, Mr. McConnell.
Good morning, Your Honor. My name is Dan Caldwell of the Attorney General's Office, and I represent the state of Florida in this matter. I don't have any new points to make other than what Your Honors asked, so do Your Honors have questions for me, or are there points you would like me to address?
Well, what do we do about Norville? Norville says bright line is this. Now, as I think Mr. McClain would concede, the makeup of the Supreme Court now may not quite share that view of the majority opinion in Norville. and they would probably be more aligned with Justice Kennedy's spirited dissent about restraining the ability of sentencing judges to hear evidence when they're evaluating the resentencing process. But that being said, obviously they tell us that until they change their mind, that's the route we travel under.
Yes, sir. Though I have to say, I think Norville is very factually distinguishable because that was an instance where an individual was on bond, committed a new offense, and then he was arrested but was not yet convicted. As Your Honor mentioned, it is far different, and actually as the trial court pointed out during the sentencing, during the third sentencing, or resentencing, I'm sorry, it's very different when someone is incarcerated. If someone is in prison for the rest of their life, it has to be a pretty high offense before the state is going to go to the trouble to then try to convict them for a third-degree felony and misdemeanor. In my time as a prosecutor, the only time I ever saw a new charge of robbery, usually where it was an actual homicide committed in prison. I have to disagree with Appellant's assertion that de novo means this legal fiction where we go back in time, pretend it's 2006, and that the Appellant's behavior over the last 19 years does not exist. That would be quite a windfall for anyone seeking resentencing to say, all right, I am rehabilitated, which is one of the factors that has to be considered under the statute, and say, I know I have perfect behavior for the last 19 years because you're not allowed to look at my behavior for the last 19 years. I think that is the key distinction. One is that Norville is about somebody who was on bond, and
Norville wasn't a juvenile either, was he?
No, you're not.
Yeah, so we have a juvenile sentencing statute that directs trial judges to make these considerations that they don't have to make for adults. I mean, if I was a felony judge, I never sentenced people saying, well, I hope this guy's rehabilitatable here. That really wasn't the factor at the time of adult sentencing. I mean, certainly they can argue that or whatever, but I wasn't statutorily required to examine that.
Correct, Your Honor, because after, as the court knows, July 2014, the Florida legislature realized, okay, we have Miller versus Arizona, we have Graham, if I remember the case correctly.
Right, yeah, you can ask Mako, he was on it.
And
he comes here at 10.
Yes, sir. Anyway, the point being that the Supreme Court of the United States decided, okay, putting a juvenile in prison for life without possibility of parole violates the prohibition against cruel and unusual punishment.
And then the Florida Supreme Court made those statutes retroactive.
Correct.
There's like 4 cases that came out.
Yes, Your Honor, there's no question there.
And so that's why we're back here talking about Mr. Monago.
And that's the legislature saying, okay, we don't have parole in Florida, so what can we do? So we have 1401, which is really concerning those multitude of factors where you do have to actually think about rehabilitation where you don't necessarily with an adult offender.
Do you agree or disagree with Ms. McClain about the question I was posing that a defendant coming in for the resentencing here can bring in his good behavior from the time of his initial conviction to now in prison? I've got my GED.
Absolutely, Your Honor. And quite frankly, I think if Mr. Monago had a perfect record, he absolutely would have brought that in.
And it would be reversible for the trial judge to say, no, I'm not going to listen to it. I've got to look at what you were back in 2006.
Yes, Your Honor. I would agree with that. All right.
Mr. Caldwell, was the issue of rehabilitation presented in front of this trial judge at the time of this resentencing?
I'm sorry, I don't...
Was the issue of rehabilitation framed by either of the parties, specifically the appellant in this case, at the time of this third resentencing?
I don't believe Appellant intended to, but it turned out that way. During his elocution, he said, you know what, I'm mature, I take responsibility for my actions, but I didn't do this.
Is it proper for the judge to question him during the elocution, or was she just clarifying a discrepancy?
She was simply clarifying, Your Honor. Actually, if you look at the hearing, the court waited until Appellant was through with his elocution, and as soon as he said he was done, thank you, the court then began to question him and said, well, hold on. You are saying you take responsibility, but you're denying any culpability. And it's also worth noting that some of the evidence submitted by Appellant in the sentencing hearing was from the earlier sentencing, I believe in 2019 or 2016, where a social worker created a whole report. I can only remember her first name was Sarah, but part of the report, which described Appellant's home life, he submitted a letter as well. In that letter, he did not express his innocence. He said, I've grown, I'm mature, and I'm rehabilitated. It is only now that he's I guess my point is, I don't know if the court had read that yet, but I believe she did based on the statements, because she said, the trial court said, I read the testimony, I've read the evidence. What are you saying?
But even if she had, I think the record should, I mean, to say I'm remorseful and I'm innocent, it's a fair comment for the judge to clarify that, because there's no reason for you to be remorseful of something you didn't do.
Absolutely, Your Honor.
So she was just, as I read it, she was just trying to say, well, you told me two things in one sentence, which is it? And then she stopped after Mr. McClain kind of objected.
And I absolutely agree with that. And as the Compare case from the Fourth District has said, it's very common for judges to question defendants during an allocution, and also that it noted that there's no case that has held that it's fundamental error to do so.
So you believe hearsay is admissible at these resentencing hearings?
Yes, Your Honor. I believe that the trial court was bound by, had no choice but to let that in based on the McHenry, yes, or something like that. Because unless I've missed it, I did not find any Fifth District case law that says hearsay is inadmissible in a non-capital sentencing hearing or to that effect. But
it's actually admissible in a capital sense,
yes,
under the statute, which strikes me as intriguing that, the person who doesn't want to be sentenced to death is under statutorily has to face hearsay evidence from the state for the judge to consider whether, but in something less severe, although this was a first-degree murder, but it was juvenile, he wasn't going to get the death penalty, that they can't hear that, because that just seems incongruous. Now, we all understand supremacy, we can't write words into the statute, it tells us that's not a good thing.
So, but that was the whole thrust of the McHenry opinion, which I'm for sure I mispronounced the name again. That was the thrust. They noted, okay, capital cases, this is admissible. The real question is in non-capital cases. So they said, we now hold it is admissible in non-capital cases. So it was absolutely admissible.
So really, I know that the opposing counsel's made that argument, but it seems to me the crux is he also did have the ability to confront. He could have gotten up and testified and said, yeah, all this stuff came in. I didn't do any of this, and I'll tell you how or why I didn't. I was defending myself, et cetera, et cetera. But he chose not to. So he wasn't deprived, as I understand the record, he wasn't deprived of the ability to contest it. He just, he pre-hearing and filed, I object to this coming in. But if the documents themselves come in, because it's admissible hearsay, then it's whether the documents itself come in, then it talks about the substance of what's in the document is kind of what I understand the thrust, the best thrust, I would say, from the appellant as to, you under Norville, you can't get any of this in, no matter what I've done. I've battered somebody every single day in prison for the last, 17 years times 365 days. It doesn't matter, you can't hear any of it.
Yes, sir, and that issue actually came up. The court in Compere mentioned it when they were distinguishing Guerra, which I believe was decided by Appellant, or about the allocution issue, where I believe defense counsel wanted to put his client on the stand, but the court said, okay, we're going to swear him, we're going to cross-examine him. He said, well, okay, never mind, we're not going to do that. The court found that was not preserved because in that context, it appeared the counsel did not distinguish the fact that he was going to do an allocution later. He had the opportunity to present evidence to be placed under oath to cross-examine it and still allocate later.
Is this a case that we should tee up for the Supreme Court to reconsider Norville?
We are.
You don't think we should do that?
No, I do not.
Well, no, you'd be reversed. So.
Well,
but I mean, from a standpoint of, certainly the makeup of it, they'll decide what they decide, and first thing is you never guess what they're going to do until they do it. But certainly if you follow Justice Kennedy's lead, he doesn't think Norville was correctly decided, and I would glean from his dissenting opinion, he would think that the evidence we're talking about here that is dispositive, I think it would clearly be something to be considered by the resentencing judge.
Yes, Your Honor. That really just goes back to my earlier argument. It would be an incredible windfall for people who were convicted as a juvenile of something terrible 20 years ago to say, you see, I have a perfect record because you cannot consider anything I've done, even though I beat your JA on my way into court here. So I do not think the court needs to reconsider Norville. I would not.
Well, we don't. I mean, just tee it up. Yeah.
Yes, that's what I mean.
We may think about it, but it would be, hey, you guys still think Norville is good law in light of here's the scenario.
Yes. Well, unless the court has further questions, then the state would rest on its brief, and we ask that this court affirm the judgment and sentence below in all respects. Thank you.
Okay. Thanks, sir. Mr. McLean, about 2.5 minutes.
Thank you. Just a few points. May it please the court. As far as rehabilitation and how it kind of played out, it was our position pre-resentencing that we were not intending to introduce rehabilitation evidence. What happened was the disciplinary reports are for good reason.
You would open the door.
We would open the door, absolutely. And obviously, we don't want this information to be considered. So then what happened was that the state introduced the disciplinary reports in their presentation.
But you do have the passage of 17 years in between the two sentencings, or encompassing all three sentencings, right?
You do.
So isn't kind of the elephant in the room that over 17 years, some sort of rehabilitation has taken place, and that was the whole point behind having a review hearing? I realize this is resentencing, but, arguably, if you're talking about the 20-year, bright line for a review hearing, you're right up against the review hearing time, correct?
Correct, and I think that's ultimately the point, is that if we go ahead and consider rehabilitation at a resentencing, then what's the point of a sentence review? There has to be a difference between the two. So you have a sentencing, which is determining what is the appropriate sentence based off the offense this person committed. Then you look at a sentence review, 20 years, 15, 20 years, 25 years, depending on the circumstances, and then you just say, is this the same person, or are they capable of rehabilitation?
Can you walk me through the chronology now that he got life again on a resentence with a 15-year review?
Mm-hmm.
Well, he's been in prison longer than 15 years. When does he get his review hearing?
So he has non-homicide offenses as well, which get a 20-year review. So he has 15 and 20. So he should be coming up pretty close on the sentence review time period.
So when you have it like that, 15 and a 20, you wait till the 20?
I think you could do either way. You could go ahead and apply for the 15 now, and then you could apply for the 20 because the.
What's the downside for him not applying for the 15? My question is more, hasn't the 15 run, so can't he just have a review hearing now?
But then he would still have his sentences on the non-homicide. So even if he was found rehabilitated, he still, has to serve the non-homicide.
I agree.
One of the nice things about the non-homicide is that you get an additional review period if you're not successful. So you get one at 20, and then if you are unsuccessful, you get one at 10.
So in this case, that would be a resentencing now, year 17, and that means 3 years later, he gets his sentencing for 20, even though his sentencing becomes effective as of now, it relates back to the original offense, correct?
That is correct.
So if you're successful here and he goes for resentence number 4, and he gets something less than life, and he gets a 15-year review hearing, could he then just turn around and say, well, thank you very much, I went from life to 30 or whatever number the judge gives, and oh, by the way, I have my 15-year review because I wasn't found to be the shooter. By the way, I'd like to have my review hearing now, and you all schedule it 2 weeks from now. Is that chronologically what can happen?
Certainly, yes, that could happen. And can I just make one final point? I know I'm out of time. So there's been a lot of discussion about the Florida Supreme Court. Obviously, we don't want to go to the Florida Supreme Court with the Norville decision in mind. But it is important for this court to write on the hearsay issue, because I do believe the statutes themselves provide the answer to the question, and the tyranny is wrongly decided. So I do ask this court to take a position on the hearsay in non-capital proceedings, because there's a difference. There's no statute that provides for it to be admitted, unlike in capital proceedings. Thank you, Your Honors.
All right, thank you, sir.
Well argued.
Thank you both. Yeah, well argued case. We're going to be in recess until 10 o'clock.
We're having
All rise.
Judge Maker's tagging in for Judge Wallace.